You're watching Behind the Headlines. I'm Pacchia. Next week, the United States Supreme Court will hear oral arguments in a major business case, the Association for Molecular Pathology versus Myriad Genetics, Inc. At issue before the court, can companies patent parts of the human body? We asked counsel for both sides to join us today. Counsel at Jones Day, which is representing Myriad Genetics, did not respond to our request, but we're joined by Sandra Park, staff attorney with the ACLU, who is representing the plaintiffs. Welcome. Thank you for joining us.
Thank you.
So, Sandra, what is the essence of your argument?
Our argument is that human genes cannot be patented. The two genes that are at issue in our case are called BRCA1 and BRCA2. They're genes that we all have, but those of us who have mutations on those genes have a much higher risk of breast or ovarian cancer in our lifetimes. And so it's incredibly important for people to know whether they have those mutations. What Myriad did here was patent those two genes. They were the first to identify them, and they got patents on them. And our argument is simply removing that gene from the body or the rest of the cell does not make it an invention. And that's the crux of our argument.
But Myriad Genetics, of course, maintains that they're not trying to patent a natural phenomenon. They're saying that the process of isolating the DNA molecules is a product of human ingenuity in and of itself, and so clearly entitled to a patent. How do you respond to that?
Well, isolation as a process was actually done for decades before Myriad obtained its patents. So that was not something they invented. What they did was they found these genes in our genome. And that process of finding those genes is certainly something they should get credit for. But that's not an invention. That's not something you patent. Just like if a surgeon removes the kidney from your body, the kidney is still your kidney. Yes, they removed it from your body, but that does not make it the surgeon's invention. There's
also this idea of extracts of natural products long being given patents. If aspirin, which of course is an extract of a natural product, if it can be patented, why can't DNA molecules as well?
Sure. Well, in that case, what we're talking about is aspirin that's actually been purified and concentrated to have a therapeutic effect. In this case, we're just talking about naturally occurring genes removed from your body. They haven't transformed those genes to somehow act as a drug, to somehow actually have some other effect than transmitting the genetic information that you inherited from your parents. And that's why we don't think our case has anything to do with cases involving drugs, therapeutics, or any of the other inventions that we actually want to incentivize.
Interesting. This, of course, isn't the first trip to the Supreme Court for this case. Can you tell us what happened at the courts below and at the first hearing that the High Court gave for this case?
Sure. So the case was filed in May of 2009 in the district court here in New York, and Judge Sweet declared that all of the patents we challenged were invalid under the product of nature, law of nature doctrine that the Supreme Court has laid out. Myriad appealed that ruling to the Federal Circuit Court of Appeals. A split panel, 2-to-1 judges, upheld the patents on the DNA, with one judge dissenting. At that point, we filed cert with the Supreme Court, and the Supreme Court was deciding another case called Mayo versus Prometheus last term. In that case, they unanimously invalidated a patent relating to a medical method on the ground that it claimed a law of nature. And so after they issued that decision, they said, back to the Federal Circuit, we're going to remand this case back to you for redecision. And the Federal Circuit, in essence, on remand, issued almost the same decision after Mayo that they had the first time. And so we petitioned again, and the Supreme Court took our case on the merits.
So do you expect the votes in this case to fall along the traditional conservative liberal lines that we've seen play out in the Supreme Court over the years?
I don't think this is at all a political, partisan issue. In fact, what our fundamental argument is that patents on genes, on the fundamental elements of our human biology, impede innovation. All of the drug companies, all of the testing companies that want to work with these genes are not allowed to do so because of the patents. So we don't think it raises this political issues that are often raised in the courts, and we also don't think it falls along neat political lines. As I mentioned, last term, Mayo was decided unanimously invalidating those patents. And those patents were of a type that many biotech companies had, and many biotech companies said they were concerned about. And the court said, our focus here is on the law, and that's what we're looking at, and these patents are invalid.
When we get to the point where we're going to see arguments, which justice are you going to watch most closely to get a feel for how the bench is ultimately going to rule?
I think certainly Justice Breyer has been very active on patent issues. He's written the Mayo decision decision. He wrote another decision in a case called LabCorp versus Metabolite a few years ago. So we know he has a strong interest in these cases, and we are certainly interested in hearing the questions he has to ask. In another case where he wrote a concurring opinion, he was joined by Justice Scalia, and so that will also be interesting to hear Justice Scalia's questions on this topic.
It's interesting just looking at the topic here. Patents have been granted for more than 3,000 isolated DNA molecules over the last 30 years. I mean, this is something that the biotech industry has come to almost rely on in a business sense. If you win this case, what incentive will companies have to continue to discover genes that make us sick? I mean, isn't this going to be a net loss for society if your side wins?
We're precisely arguing it's the opposite. In fact, I'm not so sure about that 3,000 number. That's been thrown around, but I think that's unclear whether that's true. But in fact, when you look at biotech, they are not engaged in the business of genetic testing as their primary source of business. What they care about is recombinant DNA where you actually take DNA from two different sources, stitch them together, and that makes for a more useful product like a drug. Those are the kinds of patents that we want to incentivize, but actually allowing the patents on the genes themselves stops companies from creating recombinant DNA because they can't use those DNA fragments for their new inventions. So we think it's actually the opposite, and most biotech is relying on patents on recombinant DNA and not the types of patents we're talking about here.
So, prediction time. What do you think the final vote is going to be? Who's going to win this case?
Well, I certainly am not in the business of predicting where the court comes out. I think we have very strong arguments. The Supreme Court has said for over 150 years, products and laws of nature are invalid. What we're talking about here are naturally occurring genes that you and I have that are simply removed from the body, and that patenting them allows Myriad to control all of the scientific work done on those genes. And so we think it's a pretty clear-cut case in terms of applying those principles to the genes that have been patented.
Wild stuff. Sandra, thank you so much for coming by today.
All right, thank you.
That's Sandra Park, staff attorney at the ACLU. If you'd like to learn more about the cases and issues we just discussed, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.